So we're going to get started. I have a few people chiming in, so that's good. We'll wait till a few people come in to get into the nitty gritty and the detailed conversations, the juicy questions that everyone has been asking on Instagram. I want to introduce my special guest tonight, this Thursday evening edition, is Cynthia Flynn. She is a employment attorney. She has her own firm, and the name of her firm is HACKLER, Flynn and Associates. She's based out of Pasadena, so she's a local gal, and she helps employers manage their employees and figure out what the laws are, how to implement them correctly, and how to do things correctly so that they don't get sued as employers. So she is my go-to person for, obviously, employer side COVID related. I feel like I've watched and heard you speak so many times recently about the different law changes, and it gets more and more complex as the progression of I think the stay-at-home order progressed, and then now that we're unwinding and going back, I think there's even more confusion than there was in the beginning, right? How do we go back effectively as employers so that we're not violating any laws, any rules that have been put in place? And how do we make sure, most importantly, that our employees are safe and they feel comfortable in their work environment so that they can be productive and work effectively? So I have received an entire list. I'll share it with you. I have an entire list of questions that we've organized into different categories that we received off of Instagram and Facebook. So people have been DMing us all week on the different social media platforms, giving us questions that they're curious about. So let's jump in. Why don't you tell us what your expertise is currently? Are you dealing with a lot of COVID related questions from employers?
We are, yes. I mean, over the last, 6 to 8 weeks, it's been nothing but COVID, and a lot of the questions revolve around furloughs and layoffs. And now that things are opening up, it's turning more towards workplace safety and how to bring your employees back to work safely. So I do want to mention that if anyone wants to email me, I came out with like a 4-page, basically a guide on how to bring your employees back to work safely. And then also some FAQs are also, put in there on pages, the last couple pages. So I'm happy to send that out to anyone who emails me for it.
Wonderful. I've actually included Cindy's information in the about section of this live. So her email address is there, and her office phone number, as well as her website, is there for any of you that need to get in contact with her to discuss any specific issues related to your needs. But I would really I would take her up on that opportunity to get the sheet. I think it's going to be helpful. And I think you have a checklist as well, right?
I do, yes. I have all sorts of good stuff.
I don't mean to volunteer your checklist too.
No, I'm happy to send that out as well. It's like a 19-point and section checklist. And then something actually that I'm sending out tomorrow just to my clients, and I'm happy to share with anyone else who wants it, is an addendum that an employer can add to their employee handbook that talks all about COVID-19 and workplace safety. If you email me, I'm happy to send that to you as well, as well as a welcome back letter too, that you can just use it as a template, and as you welcome your staff back, you can certainly use that as a guide.
Awesome. That's very nice of you. So, I think some people will take advantage. I know I definitely will be emailing you tomorrow morning. So let's get started. So one of the questions that this is the most, we kind of rated the questions by the number of times it was asked. So this question was asked multiple times. People DM me on Instagram wanting to know, can an employer require their employee to go back on site? So this is, I guess, for a situation where they've been working remotely and they are now ready to bring them back into the retail shop or the office. Is that a requirement that the employer can impose?
So the answer is probably yes. OSHA grants workers the right to refuse to work if they believe workplace conditions could cause an imminent harm. So if if employees see that face masks are not being used, or that things are not being wiped down well and disinfected, and people are clustering all together, then, an employee can probably refuse to go to work. But in general, no, no, an employee cannot refuse to come to work. But so the opposite would be yes, the employer can require the employees to come back on site. What we are recommending, though, Armine, to our clients is if you can have people continue to work at home at least for a little while longer, continue to do that. So that's what we're advising our clients right now.
What's the reasoning behind that recommendation? Do you think there's going to be an influx of everybody going out and going into the public in the next 2 weeks?
Exactly. As the governor opens things up under all of these phases, if you can restrict people getting together a little bit for a little while longer, just to see if we have that W effect where a lot more cases will start to rise with COVID, it just might help in the future cut down your workers' comp claims, which I know we're probably going to get into that aspect as well, and keep your employees safer for longer, if possible. But ultimately, as an employer, you can require your employees back on site.
Okay, good to know. Are the employers, as you mentioned, so they're responsible for the safe environment that they are allowing their employees to work in? So how do they do that? What would you recommend just on a very basic level for different environments? So let's take an example as an office, a retail shop, and maybe a restaurant, those 3 examples.
Yeah, so, and it's a very complex question to answer, especially during a short webinar, but OSHA and each state has specific guidelines and what is required for each of those type of businesses to operate and reopen. And it really depends on, the high frequency of customers coming in as opposed to maybe an office where you may not get any customers in for a day. And so it's really important to follow OSHA's guidelines, and they are being updated pretty regularly. So it's just a complex list of things you need to do. Ultimately, though, it's disinfecting surfaces, wiping down doorknobs, wiping down any highly touched areas such as bathrooms, toilets, door handles, phones, anything like that is pretty standard on how to ensure some safety during work hours for your team.
Gotcha. What is an employer's obligation as far as the new laws are concerned regarding keeping them safe? And then so I guess the question is, let's say the employer requires all employees to wear face masks, but the employee says, you know what, I feel comfortable doing it without a face mask. Can I just work at my desk quietly without having to suffocate? What should the employer do to make sure that they're protected? Should they put that in writing?
Definitely. And you want to be consistent throughout. That's going to be key. And if you start to have employees who, are coughing on each other or touching each other just to aggravate and stir up things, you can certainly discipline that employee. But every state has its own guidance. Of course, California has that new phase plan coming out. And it's important to pay attention not only to the state guidance, but also local county guidance as well, and city guidance might have additional information. So a lot of the times these things might be, very location specific on their obligations as employers.
So let's go straight to kind of the elephant in the room.
Yes.
What is the employer responsible for if one of their employees contracts COVID-19 and the type of job they have is the type of job where they interact with the public? So it's pretty evident that they contracted it on site.
Right. So just last night, there was an executive order issued by the governor, which created a presumption of injury for workers who contract COVID-19. So presumptions are always rebuttable in court, and I'm sure it's going to be challenged, but it basically says that anyone who, is deemed to test positive for COVID-19, and if someone else gets sick in the workplace, it will be deemed, the presumption that it's a workers' comp case. And we've been telling our clients for weeks now, if someone does get sick with COVID-19 in your workplace, it could easily become a workers' comp issue because it's so easily transmittable, right? So definitely give out all workers' comp paperwork to any employee who might be impacted. And ultimately, it will be up to your workers' comp carrier and the courts to decide how far they're going to go to compensate individuals for getting sick.
Interesting. So is the same true if the employee doesn't have too much interaction with the public? So let's just say it's an office job where they're not seeing people coming in through their doors.
Yeah, it doesn't appear to be that that's part of it. So yeah, probably separate there.
But yet, so an employee who has just a straight office position, doesn't interact with clientele, there is no clientele, they're kind of behind the scenes, and they get COVID-19 and it's not clear whether it happened on the job site. Does that presumption still apply?
Not necessarily. It's not clear, but it also helps if as a rebuttable, it's a rebuttable presumption, right? So if you can prove as the employer that somebody that they were living with was sick as well and it was transmitted that way, then it's an easily rebuttable presumption. So it'll be interesting to see how it plays out and how far, this executive order goes.
So just as a side note, I'm curious as an attorney. So let's say that it's a workplace injury and they make a workers' comp claim. What are their damages exactly? That they were out for 2 weeks and they had some, I don't know, downtime?
I'm with you. I mean, Armine, I'm not a workers' comp attorney, so I only know like this much of it. But I mean, I'm with you. Like, unless, of course, they end up getting hospitalized and dying, and then it becomes a wrongful death case. You're definitely looking at that as a possibility. But I'm with you. Like, and with the stimulus package, and with the CARES Act, and with the PPP loan, and with the FFCRA, which is expanded for leave for your employees. So if someone does get sick, they definitely have options. That's kind of rolled into, okay, you're sick and you're having to take time off that would otherwise be unpaid, maybe if you're out of sick time, but the state has come in and said that, oh, you can actually be paid for this time and we'll reimburse you.
Yeah, so I'm thinking, isn't that double dipping? If the employer is paying for their time off, and they're also, I don't know how workers' comp works, obviously, but I'm just thinking back to basics of law. Like, if your employer is responsible and they're paying you your full pay for the amount of time that you're off, and you're simultaneously filing a workers' comp claim, what are your damages? It's such a interesting, I'm really excited to see how it plays out.
Right.
Maybe we'll have a workers' comp attorney on next week.
Yeah.
And get their opinion on it. This is how we've been doing these insights.
Right.
One question leads to another that we can't figure out. So we're like, let's bring on the professional the following week.
Yes.
So what happens? One more question in line with that. So if they contract, so we discussed if they contract COVID, if they're interacting with the public versus they're not interacting with the public. And I presume that if they're not doing much interacting with the public and you've had no employees on site that actually have contracted it, then you're going to have a pretty strong case that it was from somewhere else.
Right. And what about the presumption then, of course, would not apply.
Right. Awesome. So what if they're working remotely? You're allowing them to work remotely and they contract COVID-19.
So you would just be responsible to pay the emergency paid sick leave or, under the FFCRA.
Gotcha. Let's jump into that. I know I'm kind of going out of order, but Tell us more about that. What are the requirements? What do employers have to pay if they find out that an employee, so let's take it maybe from full-time employee first. So if they have a full-time employee that gets COVID-19, what is the employer responsible for as far as paid time off?
So it would fall under the Emergency Paid Sick Leave Act. And full-time employees get 80 hours of paid sick leave. Part-time employees get an average of the 2 weeks of time that they would work, essentially. And so it's for themselves, it's 100% of their pay. And as an employer, because we were getting a lot of questions, you know, how am I going to pay for this? This is ridiculous. What are the exemptions? And everyone was like knocking on our door. We need to be exempt from this. This is impossible. But it's actually quite good because on your taxes, so first they take payroll out, and then immediately thereafter, they take the taxes associated with the payroll out, right? And what the FFCRA does is it allows employers to have a 100% tax credit on the amount that they paid during that pay period for the emergency paid sick leave. So it's a phenomenal thing if you have a good payroll company that's set up in order to actually put them in the right category so that you immediately see that tax credit.
Interesting. Okay, great.
Yeah.
I don't think many people are aware of that. So they do get a tax credit for all COVID-related payments to employees. So to summarize, if they're full-time employees, they get their full-time pay for 2 weeks. If they're less than full-time, they get whatever their average is, I presume, over the course of a 2-week period. That's great. And so is that different from sick leave in California?
So the Emergency Paid Sick Leave Act is in addition to and on top of whatever the employer already has in place. And so an employee can choose to use this emergency paid sick leave instead of their normal paid sick leave.
Okay.
So, or if they don't have any paid sick leave left, or, you know, whatever, they can use the emergency paid sick leave.
Got it. Or consecutively, maybe, if they want more time off.
Yeah, exactly.
Okay. So I want to go back to, let's imagine me, my office, we're going back, right? At some point, what do I need to do? I need to buy masks. I need to buy gloves. What do you recommend that they put in place as the very, very basic of what everyone should do across the board, regardless of what industry you're in?
So I think one of the first things you need to do is come up with a pandemic team or a COVID-19 team and figure out, okay, you know, these are the symptoms related to COVID. If you are feeling any of these symptoms, it's really about educating your staff, right? Like if anyone is feeling any of these symptoms, they need to notify this one person immediately. You know, the person in HR or the head of the company if you're a small company, but they need to know who to go to. And you need to keep that information private, of course, right? So you can't, even in a small office, you don't want to identify anyone by name if they do get sick. You want to send them home immediately. You want to disinfect their entire area. And the CDC, you know, has specific recommendations on how to do that. You want to notify any employee who was in contact with them or close contact with them. And you want to, although maybe unlikely because of the stay-at-home order, but notify any client or customer who was in contact with them as well. And not only if somebody has a positive diagnosis with COVID-19, but you also want to do that same procedure if somebody is showing signs or symptoms and has not yet been diagnosed, and you can say, you know, there's been no diagnosis yet, but we're acting as an abundance of caution to essentially warn, you know, those specific employees that they may have been in contact with somebody who was either diagnosed or may be diagnosed with COVID.
So if you suspect it, send them home. You have a right to do that as the employer. You have a right to ask them to leave. and you're paying for their time off through the new law that has come into force.
Exactly, exactly.
And then they find out they're negative and they come back to work, and then later on they contract it, they test positive. Are you paying them another 2 weeks?
Yes. Well, no, it's not another 2 weeks. It's total of that
Whatever's
80 hours.
unused.
Yes, and you can break it up however you want.
Gotcha.
You know, so yeah, and yeah, that's all I'll say there.
I'm thinking of all these kooky hypotheticals because that's what I'm here for.
Yes.
So that was my next question, was can they send home employees that appear sick, and for how long? I guess until the test comes back positive or negative.
Right.
And
now, you know, testing has gotten so much faster too. I mean, before it was 7 days until you know the results. Now it's much, much faster. So that's saving a lot of time as we, you know, open up more testing centers in California.
So the next question is, what should employers do if they're currently remote and they say, okay, guys, everyone grab your stuff. We're going back to the office on May 15th because that's when whatever order ends, or that's when I want to go back. So if an employer says that, and you do have an employee on payroll who's hesitant, who refuses, what does that equate to? Is that, does that equate to them quitting? Or is it constructive? I mean, so legally, what are we talking about? What's the label that they would have?
So I would probably put them on a leave of absence. If they are not comfortable coming home, they're out of PTO time, for whatever reason, you know, they're uncomfortable coming back. And you need to ensure them that, of course, you're taking every precaution under CDC and all of their recommendations, and you're doing these cleaning protocols and everything else. But if they're ultimately saying, you know, I don't want to come in, I'm not coming in, you can't make me come in, then you can tell them in writing, you know, here's the leave of absence for you. You do want to check probably your company handbook though, just to ensure that you can do that. Sometimes companies have very specific, detailed, you know, steps that they have to do in order to place someone on leave of absence or not. So refer back to your employee handbook for some guidance there, and hopefully it says something. But
okay.
Ultimately, you know, you can't force someone in, but if there's work available and they are refusing to take it, our recommendation is to hold off another couple of weeks, see if anything changes. Maybe they'll feel more comfortable coming in then. And then ultimately, I mean, you can terminate them, and they would not be eligible, of course, for unemployment because you are offering them work and they are actively choosing not to.
So they're quitting essentially voluntarily on their own. It's not constructive termination.
Right, right. I mean, that's how I would couch it. I would make sure, you know, any little facts though could throw that analysis off. So let me caveat it with that, you know, if they are prone to something, or, you know, I had one client, Armine, who was worried about their staff over 60, so they just sent their staff over 60
So they
home.
Discriminated.
That's an age of discrimination case, yes.
So that's a good faith discrimination. They wanted to do the right thing, and they ended up being in trouble for it.
Exactly, exactly. And so, you know, our clients have such good hearts, but sometimes you're just like, oh, you're asking for this.
So on the same line of giving a leave of absence, because I know many people are not going to understand how a leave of absence works. So let's say you put somebody on leave of absence, you say, okay, just hang out at home, and I can't have you work remotely because I need to open up my whatever retail store and whatnot. And you go and you hire somebody new because you need the work done, and they're ready to come back. And you don't have enough of a budget to have 2 employees, what happens?
I mean, that's a good question. If you don't have work at that point where they're like, okay, fine, I want to remove my leave of absence, I'm ready to come back, then you would, you know, essentially lay them off or lay off the person that you hired, your new hire, if you don't need 2 people. And that's where
you have
someone
to decide
would then
and
get
you can
work.
lay off. Okay.
Right.
Sounds good. So going back to that statement you made a little while ago about keeping information from one employee hush hush and not letting the others on staff know that there's somebody sick. Obviously that works if you have more than, one employee. So I guess, how do you make the announcement then? If there's only like 3 people total and you're there and the other person's there,
could be obvious.
Third party has been sent home.
I mean, if you have such a small office where there's only 3 or 4 of you and you're like, one person is out and you're like, someone in the office was diagnosed, it's going to be fairly obvious. But, just out of an abundance of caution, do not even say if it was her or him or, who that employee was. I mean, ultimately, people gossip, they figure things out. That's fine. But as an employer, you don't want to put any additional liability on yourself.
That guy has it.
Right.
Stay awake. So I'm going to send him home in 10 minutes. Okay. So you don't want to you don't want to blatantly call out the employee. You want to make sure, and then you notify the others on staff in writing, or is an oral notification okay? Can you just say, attention, attention, everyone. We have a confirmed case.
I think an oral notification is fine. There's nothing specific that says you have to let them know in writing.
Okay, and I'm asking silly questions because I'm trying to make light of this very, very serious topic that's stressing out, I feel like 90% of the people that I know that are employers. So, so let's say you do send them home, they test positive. What are you supposed to do then? Just wait the 2-week period until you get a doctor's note that they're safe to come back?
Right, exactly. Clearance, essentially. You can definitely require clearance. And there's been some debate too recently about whether you should even ask for a doctor's note, because so many doctors are so busy, right? And it could be hard to get in there and get that doctor's note, but we are recommending that you ask for any documentation concerning it. So, whatever that looks like, or at least something in writing from the employee in case you are audited later about some of the tax credits that you're asking for, anything like that. You just want to document it as best you can. During this pandemic, you can't necessarily demand a letter from an employee, but just do your best with documentation. I mean, that's all I can say right now.
So I'm going to summarize. You keep the environment safe, you keep the settings safe, follow OSHA standards, and those are online. So figure out what the OSHA guidelines are and do it. And you give the option of wearing the PPE products, wearing gloves and a mask and whatever it is that the employee wants to be safe. And if they choose not to, then that's their choice. You can't force it on them.
Well, so, I think it's going to depend on what
industry,
what type of, exactly, what classification you are. If you're that high risk group, medium, or low risk group, and then specifically what the local ordinances are saying in the city or county. And so it's important to pay attention to a variety of things. Other counties are a little bit more looser, others are much more strict. So, so there could be, guidance that's issued where it is absolutely pertinent that if you are even out in public, you need to be wearing a mask, whereas other counties don't have that. So, caveat there.
So I guess, so it's different depending on what type of work environment you're in. I imagine if you're in an office, you can get away with not wearing it. Whereas if you're in a restaurant, giving takeout orders or retail store, you should.
Exactly.
Logic prevails here. So some of the fears that employees reached out and asked about, and I know that you are an employer side employment attorney, which means that Cynthia represents the business owners. But I did get some questions from the employees, and I thought, you're going to know, obviously, you fight against them. So can an employee refuse to go back, which is kind of in line with what we said if they refuse to come back onto site? And so just to clarify, if you say, no, you have to come back and they refuse, it's not considered a termination. Because I know that because some people are, or they think that they're going to receive more in income from unemployment, there's some funny business happening with different employers where their employees don't necessarily want to go back, and they're like, I think I may have it. So they're working the system, right? And this isn't obviously everyone, but if the employer believes that the employee is trying to work the system, or the employee has some special circumstances, is there proof that the employee can give to say, you know what, I have a family member who is older and has, you know, cancer or a different condition, and I can't come in?
I would, as an employer, take that as at face value and work with that employee as much as possible, because this is so highly contagious. I mean, you just don't want to be caught with a wrongful death case because you forced your employee to come into work and then they gave it to their, you know, their significant other or their mother or their father or someone else. And
do you think that it would go that far? That if you had an employee who contracted it and took it home?
I mean, it's so unprecedented. I mean, you know, we've never been through a pandemic like this. And, you know, if you may want to talk to your employee though too about going on unemployment, because someone who is not able to come into the office can certainly go on unemployment. And then with the federal law stimulus package that came out, you know, if you get $1 through state unemployment, you qualify for an additional $600 a week for unemployment from the federal level. So, so a problem we're actually seeing is that a lot of employees who are minimum wage earners are getting paid more on unemployment than they were coming into the office. So we've had to talk that issue through with a lot of clients and just remind them to let their employees know that unemployment is only for a short period of time. You know, now it's extended to 39 weeks, but they may, because of the uncertainty, need to lay off again. And so if they use all 9 months now, you know, and they need them to come back now, but need to lay them off again, it just is, they're harming themselves in the long run. So that's the strategy we're trying to have our clients share with their employees.
So to use some of it, but come back, because you may actually, we may have a second scenario or a second wave where you will be laid off. So we actually got the same. So Christina on Facebook, we just asked, Cindy just answered that question that you just asked. We had the same question on our sheet about whether refusing to go back to work can then equate to collecting unemployment. And the short answer is no, because they are voluntarily refusing to go back. So there is work available and they are unwilling to take it on. So let's get into the different types of employees that might be somewhat of a protected class. So I'm referencing employees that have an autoimmune disease or have a history of something, and they would be very susceptible to getting it more so than others. What are some of the things that employers need to do to make sure that they're extra super duper protected?
I mean, if any of them can continue to work remotely, have them work remotely, make those accommodations, because I just think as a matter of course, we are going to see a rise in ADA litigation over the next 6 to 12 months as well, because any employer who said, no, you can't work from home, and now has the ability to have their employees work from home, could be coming up against some difficult ADA, you know, issues in the future.
So that is a protected class?
Definitely. Yeah. And so, you know, I would really ask, you know, do these employees need to be on site right now? If an employee cannot work at the site, or if they're limited in their ability to work because of an underlying health condition, the ADA or even the Family Medical Leave Act is likely to protect that employee. So if an employee is requesting to remain at home or refuses to come to work because of his specific condition, an employer should treat that request or refusal as a request for an accommodation under the ADA. And engage with that employee on that process.
Can you explain a little bit about what the ADA is in layman's terms?
Yeah, it's the Americans with Disabilities Act, and it protects anyone who has essentially a medical condition or, you know, disability, and over the years, you know, there are just certain, as an employer, you want to make sure that you're protecting your employees, giving them any care or accommodations that they need. And so that's what falls under the ADA, making sure that your employees have an ability, you know, to do their work as best they can in the circumstance. So for instance, if somebody is having an autoimmune compromise or autoimmune disorder and they need to work from home, just do it.
Yeah.
Just do it. That way you're not facing an ADA lawsuit later.
Yeah.
Right.
So what is this California law that allows them to take off time, the Family Leave Act? Can you explain that a little bit in layman's terms?
Yeah, sure. So, you know, under the FFCRE, the Families First Coronavirus Response Act, it expanded FMLA, which is the Family Medical Leave Act. And FMLA is generally in place for larger companies, right? If you have 50 or more employees. But what the FFCRA did is expand it to allow for employees or employers who are smaller to allow their employees to have that same sort of care that larger ones are required to give their employees. But in doing that, you get that tax credit I mentioned earlier on. So, so I guess is that.
So yeah, so it just basically provides, it requires employers to pay the 2 weeks leave if they are sick.
Yeah, so it allows basically job leave if they, it's broken down into two different ways. One is the Emergency Paid Sick Leave Act for any employee who actually gets sick themselves. Mm-hmm. And then the Family Medical Leave Act is if they are caring for a child due to school-related closures, or if they are caring for someone in their family who is sick with COVID-19. So it expanded the leave there. And that leave takes, it's like 2/3 of the employee's pay rather than 100% of the employee's pay. And it's a 2-week, essentially a 2-week pay waiting period, and then they get 2/3 of their pay moving forward.
Gotcha. So if there's mothers out there or fathers out there who have to take time off to take care of their kids because they have no childcare open, right, they can apply under the Family Leave Act.
Yes, awesome. Exactly.
So we talked about the payments, the new laws. What is one new law since COVID that every employer should know? Like, what's that golden nugget statement that you want to put out there?
One new law that everyone should know.
That you think would across the board apply to almost every employer, big or small?
Yeah, I mean, that is the Families First Coronavirus Response Act that requires all employers, you know, unless they fit into that very narrow exception, to pay the employees the 80 hours of emergency paid sick leave for certain COVID-related leave, and then also the expanded FMLA, which provides the additional 10 weeks of paid leave at 2/3 of the regular rate of pay for specific COVID-related absences.
So if an employer can't afford that, what happens, Cynthia?
So they may fall under a very narrow exception, you know, and you can basically contact me if you think you might fall under there. There is an exemption, yes. It's a very narrow exemption, but the idea is, you know, you get that tax credit instantaneously, so you don't even have to wait until, you know, quarterlies or anything like that. You get it right right after payroll comes out, you get that tax credit. And then the other thing I do want to mention, there is a new poster that came out from the Department of Labor. There's a PDF version that you can send to all of your employees, and that's a new poster. If anyone wants that as well, I can certainly send it out, but you can also look it up on the Department of Labor as well.
That's actually my next question, is what notices do employers need to post or have visible on their job sites? So
yes,
that's the poster.
That would be it.
And
yes,
if you have remote employees and on-site employees, you just email it to them.
Yes, yes, exactly.
Awesome. So we covered a bunch of things. We have one specific question, and I think we answered this. So are employers required to provide PPE products? And I think the general consensus is that yes, you should make the work environment safe based on OSHA standards,
yes.
which likely, I haven't read the OSHA standards, but I'm guessing they require you to provide sanitation, napkins or wipes or whatnot, and lots of bleach.
It's long. If you want to go to bed tonight.
Oh, yes, I will be asking you for it. Is there any, the question is there any liability if they don't? I think it's pretty obvious that there is, right? Because they're creating an unsafe work condition and they're not following OSHA standards.
Right.
So another question we got on Facebook is,
and Armine, just real quick, I think that if you don't follow these standards, you could be looking at a class action lawsuit by your employees for an unsafe work environment. So just something to keep in mind.
So you're not only looking at class action for unsafe work environment, I'm guessing labor department complaints as well, in addition to workers' comp if they do get sick. So it's a huge can of worms that you're opening up. So find those face masks. And then does it matter what kind of face masks you provide? Are you required to provide like N95s or just disposable ones?
You know, I think it again depends on what industry you're in. You know, obviously if you're a hospital, you have a different standard. But I think for most like offices, I would say that cloth mask or, you know, something reusable or something that's easily disposable is fine.
Okay, good to know. So we have a question. I don't think I understand this question, but I'm guessing that it's employment related and you will. Unrelated to COVID, do you handle DIR mitigation negotiations? I'm not sure what DIR stands for. Tam, if you're still tuned in to us, can you be more specific with your question? Maybe what does DIR, I'm guessing maybe it's direct mitigation negotiations, but it's DIR capitalized.
DIR litigation negotiations?
Mitigation. We'll find the answer for you. But if you could be more specific, if you mean direct mitigation negotiations, or does direct actually, is that an acronym for something? So we have tons of questions, right? Can an employer ask for proof of being sick? We covered this, right? You can't obligate them to have, I guess we talked about the reverse where you can't obligate them to provide. Oh, we have Tam chiming in. Hold on, let's go back to this question. Department of Industrial Relations mitigation negotiations.
Department of Industrial Relations mitigate. Call me. We'll figure it out.
Labor disputes. So Labor Department.
Labor disputes. Yes.
Yes, Tam. So call, grab Cynthia's information from above the chat box. There's a description, and her email and office phone number are on there. Again, I want to just let everyone know that's tuning in, we're not providing legal advice, although Cynthia and I are both attorneys. We're just here to provide some public information. So if you want specific legal advice, I really urge you to get in contact with Cindy and ask your specific question. But the purpose of this expert insight is just to make sure that the general information that the public may not have access to, that I get access to through my colleagues, is out there publicly so that you know, and it provides you with some indication of what you're supposed to do. If you don't know that there's a new law out there as an employer, you're not going to know what you're going to go out there and do. So We're here to let you know that there are things you need to do. You need to update your handbook, as Cindy mentioned earlier. She has been amazing and has offered so much material to you guys. So I definitely urge you to give her, I would say email her, don't call her on. We don't want you all to call her office, but just
email is great.
shoot her an email and she will share all of those materials with you. So let's move on to that next question. So we discussed employers asking for proof of not being sick. So this question is, can an employer ask the employee for proof of being sick and being positive?
Well, and so that's something we kind of touched on, where you don't, like, you may not be able to get someone who specifically says they have been 100% diagnosed with it. But I would recommend you asking for any documentation that you can get from the employee for your own records, and see what they give you, essentially. You know, more guidance has come out and said you don't want to specifically require a doctor's note, but, you know, I think it's still safe for you to say, can you provide some sort of doctor's note or some sort of documentation, just so we can mark your file with it.
So it's not a HIPAA violation.
Well, you want to keep any medical stuff separate and apart, but right, if it's a matter of, you know, allowing them to come back to work or having them stay home from work, you want to be able to document it with something and keep it separate and apart from their normal personnel file.
Right. And if they're just kind of like what we discussed earlier, being trying to manipulate the system and use sick leave or leave under the 2 weeks for the new law, then obviously you can ask for some sort of proof, any kind of proof, but it doesn't have to be a doctor's note. So Tam also commented here for you to know. She's with Untitled Construction, and okay, so Tam, she wants to know if 9 a.m. is good for you. I am a glorified secretary at this point. Cindy, is 9 a.m. okay on your calendar? So please call.
I will be getting out of a meeting at 9 a.m., but email me and we can set up a time, or just call my office and you can ask to speak with another attorney who works with me, Angela. She can, I'm sure, take your call at 9 a.m. tomorrow. And, you know, well, I'm doing a webinar tomorrow at 11 a.m. on bringing your workforce back, but it is fully booked. We have a lot of people who registered, but I'm doing another one next Friday. So anyone's welcome to join that as well.
Where can people go to sign up for your webinar? Just email your office?
Oh,
email you?
Thank you for asking, Armine. Yes, they can either email me and I can send them the information, or you can go on my website, hacklerflynnlaw.com, and there's an events tab, and you'll see all the webinars we're doing. But the one that, you know, you can sign up for is next Friday at 11 a.m. and there's a link to register.
So what I'll do is I will link your web link off your website in the description section of this Facebook Live for any of you that are interested. And again, her information is also there. Oh, it's actually he. Tam is a he. He wants to clarify. You're very welcome. He says, thank you, ladies. So Cindy's information is in the description. So let's move on. So for the employees and these are my last set of questions related to remote employees and what you can and cannot do as an employer. What are some, and this is a strange question, but I think it'll make sense once I read it through. So for remote employees, you say, okay, great, you could work remotely. You don't have to come into the office. What can you legally do as an employer to check on their accountability and productivity? Can you monitor their computer? Can you have them checking in every so often? What are the rules?
Yeah, there are definitely different programs out there where you can do snapshots of the employee's work screen and things like that. I would recommend, you know, obviously trying to stay in touch with your employees as much as possible, text, phone, email, scheduling regular check-ins, maybe doing a daily huddle. I know one of our clients does, where he has every single phone, every single employee's phone rings at 9:20 12 a.m. every morning at the same time. It's through Uber Conference, where you can schedule out meetings and everyone's phone will automatically ring. That way they can do their daily huddle.
Do they pick
keeping
up?
in contact with them. Yeah.
So everyone gets on a teleconference and says, good morning, let's do our mantra or our chant.
Yeah, exactly. Yeah.
Uh-oh, my employees are like, uh-oh, she's getting good idea. We may have to implement that, staff. Okay.
Yeah.
So you could do things like that. You can make sure that they're checking in with you. And so can you implement like Time Doctor or whatever other apps are out there that monitor the screen? Is that not a violation of privacy?
Well, I mean, that's where you need to evaluate, because if you're providing that computer and it's a laptop to your employees, then it's company property. If they're using their home computer, that could be another issue. So, you know, take care in understanding that. You know, we use Zoom for our weekly traction meetings. We do a meeting every Thursday. Just things like that. I mean, what else was I going to say about, with your remote employees, I think it's important to have a work from home agreement with them that's actually in writing that says, you know, you're still required to follow company protocol. There's no off the clock work, because my biggest fear in having your employees work from home is that they come back 6 months from now or a year from now and say, I was working 24 hours a day. I never took a break. I never took a lunch. And if they are non-exempt, then you're looking at a wage and hour lawsuit. And I think that's where a lot of companies are going to get hit.
That leads me to my next question. How do you make sure that they're actually clocking in, taking their breaks, taking their lunch breaks?
So I would really suggest you create a very simple Excel spreadsheet and just have them turn it into you every Friday. Of this is when I clocked in Monday, this is when I clocked out Monday, this is when I took my break, lunch, all these things. And you have those columns and they turn it into you once a week. That is going to be extremely helpful when an employee says to you, oh, I was working at 11 o'clock at night and you know, you never knew it, but I was. And then you have nothing to back it up on. So definitely make sure you're monitoring your time cards regularly. And
I'm sure there's different apps for that as well. Like I know my husband's firm uses an app that's on their phones, and it's super easy to use and track. But
yeah, there's all sorts of, you know, apps out there. There's all sorts of, you know, websites out there. But honestly, it doesn't even have to be anything complicated. It could just be something as an Excel sheet. Yeah. So that's what I would recommend.
But
and
I really like your idea about that separate agreement or an addendum to their handbook.
Yes.
That just reminds them.
Yeah, I mean, you need to make sure that our company hours are from 9 to 5 or, you know, 7 to whatever, 6, whatever your company hours are, and that you want to make sure that you are, that they're available during that time. So it's important to lay it out.
Okay. So we have a question. Are employers required to provide reimbursement for use of internet? And then I'm going to throw in phone as well, because I know that a lot of employees are using their personal cell phones possibly.
Yes. I'm so happy whoever asked that question asked it, because
I know I heard you the last time at the last meeting.
Yes. I think employers are opening themselves up to another wage and hour lawsuit if they are not reimbursing for internet and cell phone. And case law says there doesn't have to be a specific amount of the reimbursement, just something that is reasonable. And so you don't have to reimburse an employee for $400 a month on their cell phone because they have their mom, brother, kids on it. But just something that's reasonable. And then same with internet. I think that that's a really good point. You absolutely want to be reimbursing for internet. And just because an employee already has cell phone or internet doesn't mean that the employer can essentially take a windfall by benefiting from those things.
Okay. And I want to stress to employers that when you're reimbursing for an item, you're not just upping their pay and then having taxes deduct from it. Make sure that it's a clean reimbursement.
Yes.
I can see
Yes.
that happening with some people,
Yes.
putting in a $50 reimbursement, but then by the time deductions come out, it's like $20 for the employee.
Yeah.
You don't want to do that. So be very cautious and careful. So I think we've discussed most of the questions that were on my Q&A list that we pushed out onto the different socials. We talked about workplace safety, what you need to do, and Cindy mentioned that there is obviously OSHA regulations and checklists available, so contact her for that. Employee fears and how to psychoanalyze them as an employer, because now you're going to be playing therapist as an employer and making sure that you tread very lightly, because you don't want, as Cindy mentioned, to violate any ADA laws that are in place. And then we also covered remote employees and also obviously the plethora of new changes and new laws that are out there. So if you're an employer and you have more than one employee and you don't have a handbook and you don't have procedures in place and you're just flying by the seat of your pants, I really recommend at the very least you get on board and you get that very important document in place. Just have a simple handbook drafted up for you. Cindy, your office provides those services, right? Yeah, so just have a very simple handbook drafted up for you that you can tweak and change up as the laws change, like in this particular circumstance, and you can have someone on call and you can use them as you go. And then, you know, make sure that you are posting all of the signages that is required of you, and that if you do get approached by an employee and you don't know the answer to the question, that you don't guess. This is like a deposition. Don't guess what the answer is going to be. Say, I don't know, but why don't you go back to your seat or your office or your area and let me find out before I obviously create some liability for me. Just based on these questions, you guys can already tell if you're an employer, you had liability, but now from here, we've gone here. There's workers' comp liability, employment liability, labor disputes, and ADA violations. So Cindy, I know that you have a little baby at home. I don't want to keep you all night long. Otherwise, I feel like I can ask and we can go on forever. But I'm trying to limit these to an hour's worth of time. Thank you so much for taking time out of your night and your relaxation time, right? This is your time to regroup and re-energize for the next day of stressful work that you do. So thank you for joining me tonight. I really, really appreciate it. And again, we're not providing legal advice, everyone, but if you need legal advice, you can easily reach out to Cindy. Her information is in the description box. I will also link the link to her webinar that she's having next Friday for preparing to go back to work. And that's pretty much it. You're welcome. So people are thanking you for the vital information. Thank you so much, Cindy.
Thank you. Thank you.
All right, everyone. Have a wonderful night. Bye, guys.